But first tonight here at 6, a new push for change to Indiana law following a WRTV investigation that revealed gaps in the system meant to protect children in the classroom.
WRTV Investigates. Kenney explains why some say schools need to be notified of misconduct allegations much sooner.
In Indiana, schools only have to notify the Indiana Department of Education if an employee has been convicted of certain felonies. Child advocates say IDOE, the state agency that can suspend or revoke a teaching license, should know if a teacher is accused of misconduct with a student. Former Beech Grove teacher's aide Michael Lizelle is charged with performing sexual conduct in the presence of a minor, a felony, as well as public indecency, a misdemeanor. The charges stem from a 2019 incident at Beech Grove Middle School in which 2 students reported Lizelle masturbated in front of them while watching pornography on his school computer. Beech Grove City Schools says it did not notify the Indiana Department of Education, the state agency that can investigate misconduct allegations and suspend or revoke teaching licenses. WRTV Investigates uncovered schools do not have to report allegations, arrests, or charges, even if the alleged misconduct involves students. Indiana law only requires schools to notify IDOE if an employee has been convicted of one of more than 30 felony charges, including rape, child molesting, child seduction, and performing sexual conduct in the presence of a minor. Lizelle has not been convicted. The criminal case is still pending against Lizelle. 2.5 years later, he's pleaded not guilty. Beech Grove City Schools tells us when the case concludes, we have every intention of fulfilling our legal obligations for reporting. But child advocates say this wait-and-see approach needs to change.
The reason schools don't want to provide the information is that they would rather save face than save children.
Terry Miller is president of Sesame, Stop Educators' Sexual Abuse, Misconduct, and Exploitation.
There are better statutes out there.
She points to laws in other states that require schools to report allegations to the Department of Education, not just convictions. For example, Texas law says schools have to report when there's evidence a school employee was involved in a romantic relationship with a student, or solicited or engaged in sex with a minor. The state can do its own investigation, and if they determine the allegations are true, the educator will be placed on a statewide do not hire registry. Pennsylvania has a similar law that requires schools to share with the Department of Education within 15 days if an educator is accused of sexual misconduct with a child or student.
It doesn't have to be just reporting a conviction, but any incident of sexual misconduct must be reported to the state. So that's where your language needs to lie, is with sexual misconduct, immoral acts against students. You know, that's the kind of language that Indiana should be looking at, and not just convictions.
Advocacy group Child USA agrees.
You are in Indiana so far behind. The state needs to up its game here, and what they need to do is require reporting to the state for grooming behaviors, suspected child abuse.
Pennsylvania Senator Anthony Williams was the driving force behind Pennsylvania's educator misconduct law. We shared our findings with him about Indiana.
I'm sure most are like many states, they're just not aware of the gaps. And now that somebody's brought the fact that it's not a gap, it's like the Grand Canyon.
Getting a criminal felony conviction in a case involving a child is very difficult, which is why Williams says that should not be used as the standard for reporting to the Department of Education.
Foreknowledge is obviously always forewarned, and that's the manner in which we want to approach this. There's something in your background, not a conviction, but if there's something in your background, it is to everyone's benefit to investigate it beforehand.
Reporting allegations to the State Department of Education allows any state to be on notice, do its own investigation separate from any criminal process, and potentially suspend or revoke that teacher's license. If Pennsylvania determines a complaint is not legally sufficient, the state dismisses the complaint. Complaints and investigations are not public record. The public can only find out about a case once the state imposes discipline against the educator. Shaughnessy Terrell is an attorney and former sex crimes prosecutor in Marion County.
If there are charges filed, that means that probable cause exists. And that's not easy to get past. I mean, it's a little bit of, that's a burden right there. So it's not like it's willy-nilly every person who accuses somebody of something all the time. No, it's not going to be those allegations that don't get substantiated in some way. If there's enough there to charge a crime, then the DOE should know about that.
Terrell points out oftentimes suspects plead to lesser charges.
And so it's a huge gap in protecting kids.
Beech Grove would not be required to notify the state if Lizelle is convicted only of public indecency. It's a misdemeanor that's not on the list of offenses schools have to report.
Drug dealing is on that list. Why is not masturbating in public?
Another potential gap, Indiana law requires all of us to report suspected child abuse or neglect to the Department of Child Services. However, state law does not outline a process for DCS to share that information with the Department of Education. IDOE says they are in regular contact with DCS regarding issues relating to educators and allegations of abuse and neglect, and that while state law does not specify a process, IDOE and DCS undertake this coordination with the safety of Hoosier children, serving as the top priority. IDOE also points out that state law requires schools to conduct an expanded criminal history check and check the Child Protective Index, which should identify any substantiation of abuse or neglect. We asked the Teachers Union, the Indiana State Teachers Association, whether it would support requiring schools to report misconduct allegations against teachers to state licensing. ISTA told us, we support changes in law that would require prosecutors to report any charges that have been filed against a school employee to the Department of Education. We also encourage the IDOE to use their ability under current law to receive reports from the Department of Child Services, which would include any reports involving school staff. As we told you in August, Indiana Senator Aaron Freeman is already looking at making changes to Indiana law.
You know, when you get the first allegation, I mean, I think the Department of Education needs to be made aware of that, and somebody's license should not simply be dependent on a conviction. I mean, we should investigate that. We should want the Department of Education to know about it and do a thorough investigation.
The Department of Education can also take action against a teacher's license without criminal charges or convictions. We've reported on a teacher who was accused of misconduct by several students. He was never charged, but his teaching license is now revoked. The next legislative session kicks off in January, and we will be keeping an eye out for any bills on this topic. Working for you, Kenney, WRTV.
Kara, thank you. The Indiana Department of Education says it will continue to monitor the case against Lizelle, which is scheduled for a jury trial on November 18th of this year. WRTV Investigates reached out to Lizelle's attorney, who declined to comment.